Okay, good evening, guys. My name is Joe Porto. I represent Caesar and Josephine Tomei. I practice law with the law firm of Porto, Parisi, and Caldwell. I will try to keep my comments to slightly less than Vinny's. This is an interesting legal issue that we have here, but I join in Attorney Vautre's opinion, and I make the following comments. I happen to think the application is defective. I agree that the road is part of the subdivision. That is standard on every application that certainly my office has ever been a part of in every form that I've ever seen. It makes absolutely no sense for somebody to try to develop a piece of land they have no right to get to. The cul-de-sac extension, of course, excuse me one second, a separate issue. It is beyond 1,400 feet, subject to your discretion. My understanding is, and I'm coming to this a little late in the game, my understanding is that the municipal fire and police have weighed in and have indicated that it is not a concern. I'm sure this commission will give that the appropriate consideration. I also, having come to this a little bit late, didn't have the benefit of hearing the engineer's testimony, but should this commission get to the issue of actually considering the two rear lots, it is my understanding that the topography slopes towards Mr. Tomei's property. This commission should give some consideration to appropriate soil and erosion control to make sure that the plans address that issue appropriately.
Excuse me, Joe, on the map behind you, which one is the Tomei's property?
It is, their address is 118 Cricket Lane. Mr. Kaplan, I believe, Caesar, is it?
No, it's in up top.
This one here?
That one's, okay. It's the east, right? Yeah, okay.
Okay. Yeah, and lastly, while not necessarily exactly on point, I found Connecticut General Statute Section 8-27, which discusses the ability to build on an unaccepted street. And the statute reads in part, a municipality having a planning commission may by ordinance prohibit or regulate the issuance of building permits for the erection of buildings or structures on lots abutting unaccepted highways or streets. I acknowledge it says issuance of building permits, but here's my thinking. The developer, in our opinion, the street, the paper road, is not an accepted street. The developer doesn't have the right to cross the property owned by the clients of myself and Attorney Votri. Therefore, he can't develop it. Beyond that, I believe this ground has already been covered, and I can't wait to hear from Mr. Pellegrino.
Okay, couple of things. First of all, I think you have all of the signatures that you need to entertain this application. I am confident of the fact that you have the signature of the property owner of the property to be subdivided.
So that your position, Bernie, I'm sorry, is that the access road is not part of the property that's being subdivided?
It's already done. You did it in 1961. That land was part of the Grillo subdivision. And when that subdivision was approved, the right-of-way that we are proposing to utilize was already part of a subdivision that was dedicated for public use. So that land is not part of this subdivision. That is the land that was dedicated for public use and approved by you for such use in 1961. We're just going to improve it, continue the cul-de-sac on our land, and access it over land that was already subdivided and approved by this commission in 1961.
So we don't need the signature of the owner of that strip?
You had it in 1961.
So
That's done deal.
So it's your position that to demonstrate that that is not a portion of this subdivision application, is that was already subdivided, is that correct?
We all agree. Ken agrees. That was already done.
Well, we know that was done, but my question is, are you saying
We're not required
are
to
you
do
saying
it.
that that's evidence that that is not a part of this subdivision application?
Yes, that's
Okay.
evidence, and we abut it, we clearly abut it, I don't think there's any dispute that we own property that is adjacent to the approved spur that was created and dedicated for public use in 1961. So we do have a right to file the application because our property abuts the dedicated spur. I mean, clearly, this was meant to continue with a road for development to the north. That's why it was part of the subdivision as such. There's another road over here. Some say, perhaps it would have gone all the way through. Maybe that was the plan, but clearly, the contemplation by this board in 1961 was something would happen with this property, and they would be able to access it through what we're calling Christmas Tree Lane. So, issue number one, you have all the signatures that you need. Issue number two, we clearly have rights, because we access the dedicated land. Dedication and acceptance are really they're separate. Step one is dedication. In this case, it was done by your predecessor's approval of this subdivision. The land is dedicated for public use. The next step is ultimately the construction of the improvements and the acceptance of the roadway. Acceptance is related to dedication, but it's really a separate legal concept. Dedication is dedication. I think we all agree that that's been done. Acceptance is acceptance, just like in the normal course. This one, just like the rest. It's dedicated. If you improve it, the town is telling you we will accept it, because why would we have permitted the dedication? It's for public use. If you come before the board with a subdivision that meets your regulations, you can, in my opinion, utilize the roadway that has already been dedicated. And then you build it, and then it's accepted. They're two separate pieces. The dedication, I think, has been perfected. Acceptance hasn't happened yet. That happens next.
I was just referring to, I think it was a case that Vinnie brought to our attention where it talked about, dedication, and then the concept, the legal concept was dedication, and that consisted of two things. One, the applicant showing some intention to
Submit it.
Right, for public use, and then the town accepting it, evidencing some intention to accept it for public use. That would be by vote of its legislative body and acceptance of a deed of some kind.
Correct. It is a two-step process. I think we've already got dedication, and hopefully someday we'll have acceptance after it's improved in accordance with the town standards. I had this, Joe will remember this subdivision because I was involved and we discussed it on a number of occasions, but the subdivision that I did in North Haven, Hunting Lane, 4-lot subdivision, is the exact same scenario. Ravenswood Construction, ironically, had developed a horseshoe roadway called Winchester Drive in North Haven. At the end of Winchester, they dedicated a spur of land, and it went between two lots for future roadway use. My client owned a strip of land that had legal access, had actual access, on another road through which a river crossed. Couldn't really get back there. Came to the town, got 4 lots at the end of the existing right-of-way, continued that roadway a little bit and did a cul-de-sac. The exact same scenario. 2006, same thing. So it is not unheard of. It happened, and it's happening more and more, quite frankly, because it's parcels that are a little more difficult to develop. It's harder to find that good frontage, but these roadways are there, and the property owner, until such time as it's dedicated, it is abandoned, has certain expectations and rights that someday their land could be accessed through the dedicated right-of-way for future development. That's what we have here. And so I think you have all your signatures. I think we do have rights to propose improvements over the right-of-way to access the land. The town bonds for that. Essentially, any developer is basically building town roads at the insistence of the town for the development of the land. The town bonds that work to ensure that it's done properly, and if it is, it's accepted.
You answer Attorney Votra's argument that the applicant can't go on that property to accomplish these improvements.
I look at the map, and that's my answer.
So the applicant can go on the property?
The applicant can go on the land, there's no doubt about it. Any rights that his clients have are subject to the right-of-way. Since 1961, when they bought it, they knew that there was a right-of-way there for future public use, and it's still there.
That's one of the issues that I've wrestled with this application.
And Judge Hodgins says it's still there.
2000, even when it came in 2003, is that, obviously, you hate to see people who have lived in town for a considerable length of time have a road go through the property that they bought, but they bought that property with full knowledge that there's.
What year did they buy it?
I'm not sure. It was originally it was either Brennan's or the Tomei's bought it from Bartosetti, so Bartosetti was the original party. I'm not sure when they purchased the property. But either way, both of those property owners, the Brennan's and the Tomei's, bought this property with full knowledge that this right-of-way existed. As did Mr. Denny purchase his property with the right-of-way and the knowledge, or at least the thought, that he had an opportunity to access his property through this right-of-way. Had the Brennan's and Tomei's sought to abandon that property, Mr. Denny would have had the right to go and try to fight that abandonment at that time. If we were to deny, this chance, we in effect would be making a decision and denying Mr. Denny a right that he bought that property with full knowledge that this right-of-way existed, and his at least apparent knowledge that the right-of-way gave him access to his land. So we'd be taking away something from him, and I don't think if we move forward with the decision that, again, I think it's going to be decided by a court, not by us. But I don't think we'd be taking anything away from the Brennans and the Tomei's, because they bought this knowing that this was a possibility. And I'm just shocked that I'm sure it was their legal advice told them don't bother to seek the abandonment, but I think it's clear that was poor advice.
I have one question. Is it 3 out of 4 tonight, or is it 4 out of 4?
For the, what? For the
For
cul-de-sac?
yeah.
The cul-de-sac is the supermajority, which counts as 4. It was the supermajority of all members, not members present, so it would be 4 members for the cul-de-sac.
Okay.
The other issue is a simple majority. Yeah, so we could approve the cul-de-sac length, based on our history and based on whatever we do, and deny the subdivision application, because they really are 2 separate issues. One is dealt with a safety issue, the other is.
We don't actually, if I remember correctly, because I do recall something like this, if we deny the cul-de-sac issue, we don't have to reach.
That's correct.
The subdivision
Well,
issue.
because it's a dead issue then.
Right.
Yeah. But we also should, if we go down that road to denial, we should state the reasons for denial. Because if we don't state the reasons for denial, then we're stripping the applicant's ability to contest that denial, which might happen too, so.
If I may.
Well.
Last word. One error, and I think the reasoning is, and it's good to look at Judge Hodgson's decision. Judge Hodgson, for those of you, she's no longer on the bench, she's left the bench, but made a pretty intelligent decision here, and Mr. Denny was part of that decision. The decision she made was not on the adverse possession claim, but on a quiet title action, and the issue was to deal with the dedication. Mr. Denny was named as a party to that action, And Judge Hodgson, in deciding it, he did not decide that there's a right-of-way across the property. In fact, that she decided that there wasn't a right-of-way across the property. What she decided was that the property was subject to a dedication, and the town could abandon or the town could accept it. In discussing the time period, she referred to a Supreme Court decision that said, well, that time might be relevant, but 20 years might work. We're now at 40 years, and I'm sorry to say I wasn't here for the first application. I was about 6 months old. I was probably busy with other things. But what Judge Hodgson did decide was that Harlan Denny had no standing as a party to the quiet title action because Harlan Denny had no right to the roadway. What she said...
Who brought the quiet title action and against
It was the Barticellis and the Tomays were party... Barticellis and the Tomays were party to it. My clients weren't there. They didn't own the property at that time.
And who, they brought it against whom?
Harlan Denny and the town. Harlan Denny and the town. And Denny made a very interesting argument trying to salvage standing. His argument at the time was, it's an abandoned road. And he said, I've got standing under 13A55 of the Connecticut General Statutes that says, if you own property bordering on an abandoned road, you have a right-of-way over that property. And what the judge said is, the remaining objection, now, two things happened. First of all, you understand this was tried to a trial referee. It was Dick Sperandeo. So there was an objection to the finding of the trial referee. One finding was not objected to, was that the property was not landlocked. So there was a judicial determination that the property is not landlocked. So in terms of all the rights Mr. Denny may or may not have, he's got other access to the property. So he does not have an easement across this property because he's got a landlocked site.
You mean no prescriptive?
No prescriptive
Okay.
easement. Now, what she says is, the remaining objection, based on a claim of legal error by the referee, is the defendant's Denny's claim that he should have been determined to have standing pursuant to 13A55 of the Connecticut General Statutes. And that statute said, at that time, property owners bounding a discontinued or abandoned highway, or a highway, any portion of which has been discontinued or abandoned, shall have a right-of-way over such discontinued or abandoned highway to the nearest or most accessible highway. The court finds that the referee correctly determined that the area at issue had never been accepted as a road by the town, and not having been accepted, it could not be characterized as having been abandoned. The court finds no error in the referee's legal conclusion that 13A55 Connecticut General Statutes did not confer standing on the defendant Denny under the circumstances. He was punted. He was out of the case. He asserted a right-of-way due to abandonment. So there's no finding in Judge Hodgson. I mean, for all the talk about right-of-way, there isn't a right-of-way. All she determined is there is a bald dedication that has neither been accepted or abandoned. So Denny has no right over this property that's been determined by any court or by any prescriptive easement. So there is no, and nobody has showed you any law that suggests a dedicated but unaccepted highway creates any rights of way. So Denny, the applicant here, does not have any rights to that property. Now, what the town's rights might be, you're all right. I might disagree with the town on certain things, but...
It's a quiet title action. I mean, I understand how it was disposed of as against Denny, but what about as against the town?
The only conclusion that the court made in terms of the town, the court enters judgment determining that the plaintiff's interest in the area between their respective properties that is dedicated for future highway use on the Grillo subdivision map continue to be subject to such dedication until such time as the land is accepted by the town for use as a road, or the dedication is revoked pursuant to the application in accordance with 8-26 of the Connecticut General Statutes.
So
It's a dedication.
So
That's all.
So the court quieted a title in your client's predecessors,
Yes,
subject to some rights,
of dedication,
whatever they are,
but that...
to the town.
whatever to the town, clearly not the Harlan Denny. Clearly there is no finding of an easement. There has been nothing before you that suggests any right-of-way by Mr. Denny. And this decision, because ultimately Denny was found not to have even standing to challenge the issue, was out of luck.
I guess
That's a problem.
the question that I still have is, when we started this grand circle, and we're back to the beginning, I think, in my opinion, is this a decision for this board to make, whether he has access to this or not? Or can we proceed with the subdivision application before us and let Mr. Denny and whoever else is involved fight this off in another day?
But I think without access to the property, you have to deny the application. It's inaccessible.
If they sold me half of that property
Mhm.
with those 2 new lots,
Mhm.
I wouldn't have a problem getting in there then, correct?
From the north part of the property.
No.
I mean, I'm sorry,
From Christmas Tree Road.
you could not get in there on Christmas Tree Road.
No.
Oh, if you bought it from our clients,
If I bought it from your client.
you'd have to buy it for, you'd have to.
And
yeah.
that would be landlocked, then that's the only access way I could get in, correct?
If they,
If they kept their front part of their house,
it's not landlocked because of the other access way to the
no,
property.
if they kept that and they only sold me the back half,
The back half.
then it would be landlocked.
Well, that would possibly be, but
And
then,
then that's the only access way in.
yeah, but that's not the reality of the
Right.
situation.
Okay.
And so, the issue becomes, is if you make a finding that there's access to this property, there is no accepted public road, and there is no right of Mr. Denny to access that road. He hasn't done, you haven't seen one piece of paper.
Rick, is your question?
I agree that he has no
Yes.
right because of what happened in
Yeah,
court.
yeah.
But if I purchased the back half of the property
Mm-hmm.
and he kept the front half, then it becomes landlocked.
Yeah.
I have a legal right to go in there and build 2 lots.
Well,
If you create your own hardship,
Or 1 lot, whatever.
you'd be
2.
creating your own
Yeah, no,
hardship.
Rick, you mean that if you have a landlocked piece, you have an automatic right to get to it?
No, I'm not buying a landlocked piece because it's 1961, they put a road in there.
Oh, no, I agree with that.
Right.
But, okay, I understand.
Of course, the
Right
subdivision,
now, they have access to the land. They can't claim landlocked.
they can't.
Right, that's what I'm
They can
agreeing
access
with you.
from, I mean, there may be issues with roads or whatever,
The
but they
land
could
could
build.
be 200, whatever, acres long.
Yeah,
It
they
doesn't
can
matter,
access,
they
they
have
can
access.
access
Right.
through another direction
Correct.
and access the
Right.
property.
So they have
But
access.
the
to
plan
that.
that's before you is the access for this property. They have not come before you saying, we're going to put a road on the other side of the property.
No, right,
And the reality is there's been no subdivision of the
Right.
property at this point.
Right.
That, and in fact, the argument would be is if one subdivided the property in order to create a landlocked situation, it would sort of
well, it's
be
not creating
tough-
landlocked because it's not.
It would be tough luck to
Right.
you. I mean, it would be hardship.
We were actually
they-
instructed, I can't remember if it's under 8.2 or 8.3, but to provide safe access to properties. And I think that clearly what weight it has in this argument is, there's no way that the other access to this property could in any way be described as safe access.
Yeah, I think that there's been plenty of testimony that if this applicant had tried to access this property through Dogburn,
Burn, I believe. it is.
Dogburn, that would be something that would be a safety issue, and I think we all are concerned about that
I
part.
thought they had access already there. Is there a,
No, but-
There's a right-of-way there, but what I'm saying is that it clearly is not safe access.
there's not a
But then
house in front?
But in terms
Pardon
of
me?
There's not a house in the front?
No,
No?
that's a separate piece of property where the house is.
Oh, it is?
Yes.
the right of way.
What he's saying is Mr. Denny actually, he
Owns
owns
the
a
other
home there,
in
but
front.
where the home is a separate piece of property than this piece of property that's seeking to be subdivided.
And
Oh, it
the
is-
problem-
They're not in one lot.
They're
You know,
not?
it was,
Okay.
you know, he owned this piece of property long before he bought that house.
See, and you're playing on the term safe access,
Well,
but the
just-
second
I
part of
think
the
it's something
phrase
we
is
have to
access.
consider, you
The
know.
second part is access,
Yes.
and this way he doesn't
But
have
he's
legal
not,
access.
he's not proposing a plan of subdivision utilizing the access off of Dogburn or Dogwood or
No.
whatever it is. That's
See,
irrelevant.
I thought it was all one piece of property, so he's not landlocked. But you're saying it's 2 separate pieces of property.
It is 2 separate pieces of property.
Okay.
But here, he can't prove access because he can't prove a right to access. In fact, the court said that he doesn't have standing to make that claim. So, unfortunately, I think he's still, in terms of trying to demonstrate to you that he can ever have access to this property, he's dead in the water at this point. I mean, we have a judicial determination that says he has no challenge, he has no right to challenge or make a claim that he has a right of access by virtue of an abandoned roadway, and that was his claim. He went to court. So we talk about notice to him. He hired a lawyer, went to court. He was brought in rightfully by the parties and asserted his rights to access the property, and the court determined he didn't have them. And so it goes back to suggest that the town may have rights under the
Did the court
dedication.
determine that he didn't have them, or did the court determine that he didn't have them under CGS 13A55.
He just said, the only claim he made is he had a right to access under that statute. There were no other arguments
Okay,
made.
but that's what
To
the
the best
court,
of my knowledge.
that's what the court decided,
Yeah.
that 13A55 didn't
Yeah.
apply here, so therefore that was
Well,
irrelevant,
but
correct?
they also threw him out of the, they basically determined he had no standing to challenge title to the property ultimately, and access to, he had no, the ultimate significance of the decision is he had no right-of-way. I'm assuming, had he had any other claim of a right-of-way, he asserted it at the time it was being litigated. He'd be precluded if he didn't, because it's something that would have to be raised in that proceeding, and so he didn't raise any other claims. So he put himself into that predicament ultimately. And so he claimed that he owned some interest in that property, a right-of-way that was to some extent prescriptive by virtue of the roadway issue. And because the court made the determination that the property was not landlocked, and by the way, his counsel didn't challenge that finding, did not challenge that it was not landlocked.
I don't understand. You say the property's not landlocked. If they don't own the front lot, it is landlocked.
No, it looks like
There's a 50-foot, there's a 50-foot,
right-of-way that goes out
right
to the
away,
right.
not a right away, there's a 50-foot panhandle
Well,
that goes to the
yeah.
front.
Okay.
And the court, and we have a judicial determination, and he could have challenged it. The process with the trial referees, you get a lawyer trial referee, and you challenge the findings. Once the judge rules on it, they become, part of the judgment. So, we don't want to read beyond the Hodgson decision, which simply says there's a dedication, and back then, in 1992, it hadn't been long enough for it to be abandoned. Well, now we're, 16 years later, I'm not so sure that a court would rule at 47 years.
But again, that's not a determination for this board.
That's not
Trying to
a
second guess what a court might decide is.
But the applicant's the one who's got to come in here and prove he's got access to this property. And if you can't prove safe access to the property, you have to deny the application. Thank you.
I just want to encourage you at this witching hour to, unless there's much more that the public wants to speak, you may want to kind of start to move the question, because I think you've beat the horse. But from an opinion standpoint for the board to consider is that the issue, in my view, is not the applicant's ownership in the right-of-way. The right-of-way exists in favor of the town. So if you find that that is a public right-of-way that can be developed as a road, irrespective of Mr. Denny's ownership interest, which I agree has been adjudicated as not having any, if you determine that this road should exist because the original intention of this subdivision in 1961 was to put the spur to access the back lot, there's access. It's the town's right to put the road there, and if that road is built by the town or by a developer on behalf of the town, I think who constructs the road is not germane to the issue of does the right-of-way exist? And according to your subdivision map of 1961, which has never been abandoned, the right-of-way exists. And so to go off on a tangent of, well, let's read the Judge Hodgson's decision as to what Mr. Denny's ownership interest is or rights vis-a-vis this property, I think that's taking you down another path that you shouldn't go.
Does Attorney Votra concede that the town has rights over that? Again, I may be,
He may-
rehashing this, but I mean,
I
think he-
suspect, and without getting into
I don't want to ask
hours-
him if you concede anything, but
You can always refine things. The truth of the matter is the rights the town has are only the rights of dedication. Since they have chosen not to accept it at this point, they have the inchoate right to accept it or abandon it. That's all they have. There is no right-of-way to the town at this point.
let's say the town wanted to engage the applicant to build the road there. Could they do that?
Well, could they do that? I would imagine they would have to,
Let's say we,
if consistent with
let's say you're
town
right.
rules.
I mean, let's say you're right. The applicant has no rights.
The town may be able, I'm not going to, there may be issues about the title under the ground, but the town with the dedication could accept it and choose to build a road. Whether or not they can then enter into a contract with Mr. Denny to do the construction may be a different issue. And whether or not the town has the power to do that may be different. But the problem is as you sit here as a board, The town hasn't done that. You don't know that they're going to do it. You have, we know one thing, Mr. Denny has no right to build.
But if we approve the plan of subdivision, somebody's got to do it. Somebody's going to, the
Or it
applicant
dies.
is, huh?
Yeah, or it dies.
I mean, the applicant.
Another example is if you look at the Stu Leonard application, their whole point is to access through the Edison Road extension, which they didn't own. It was owned by a couple different parties. They didn't have, the town took some of it by eminent domain, if I recall. So Stu Leonard's didn't own it. The road is not constructed. It's not even there. It's just proposed. So we accepted that. I was opposed to it, but they accepted that subdivision, that division of that land, based on things that did not exist, and they did not own it, too, is the
But you
important
have
part
to
there.
be able to find that Mr. Denny could build this road. You don't
No,
know that he can build this
we didn't
road.
know that Stu Leonard's had the ability to build that road, because they didn't own that property. Part of it was owned by other parties. The town went in and took some of it by eminent domain. I'm not sure, I think some of it was sold to the town also, an outright sale. But there's nothing to say that, first of all, they were going to win the eminent domain. There's nothing to say that the other parties would have sold the property to the town, which they inevitably did. But it was the same thing. It was the proposal. If that didn't happen, then that application would have had to come back. It would have died and said they would have to come back with another plan.
But it was you who said that you have to be able to establish safe access to the property. Right now, Mr. Denny can't establish
Well,
access to the property,
he's-
never mind safe.
I think he's demonstrating a means of safe, or his plan for safe access. If it doesn't work, that's his problem.
If he can build this Christmas tree lane as he proposes,
But he can't.
well, let's say, for the
he
sake of
can't.
argument,
No,
that
see-
he can. I mean, he
can't.
will have safe.
The thing
But the
he's
reality is he
saying is,
can't, without us.
no,
Or without the town.
if
Or without the town. We don't know
if
if the town
Danny
can
didn't
do it.
own the land, he could build it, or anyone else could build, he can't build it, but someone else could build it, because he didn't have a court case against him.
No, at this point, nobody else can build it other than whatever rights the town has to accept the dedication. And whatever status that might be at the point in the
Right,
future.
but I'm just saying,
But
if
he's
somebody,
established no suggestion that the town is going to do that. My client couldn't build the road. My client couldn't build the road because he only has half that property.
But you do concede that your clients don't own that property outright, free and clear.
No, we own it outright, subject to a right of
You don't own it,
dedication.
you don't
Yeah,
own it,
Yeah.
you don't own it free and clear. Of,
well, that's-
some rights in the town.
There is some rights in the town.
okay. And Attorney Pellegrino takes a position that, that the rights in favor of the town would be sufficient to allow construction of this
He
road to go
takes a
ahead.
significantly, in terms of the dedication, he concludes that the dedication creates a right-of-way. But there's no law that supports the argument that a dedication creates a right-of-way. The acceptance might, the dedication doesn't. And I think he acknowledges that dedication and acceptance are very different things. So right now, as the record stands, it is clear that Mr. Denny has no right. Mr. Denny, if he walked across that property, could be arrested for trespass.
What about Mr. Pellegrino's view?
Why are we in the middle of this?
What about Mr. Pellegrino's view that
And Mr. Pellegrino could be arrested for trespass, too.
that is not part of the subdivision, though, because what he's saying is that Mr. Denny's plan, which shows that road, shows a road that's on an already approved subdivision. He's not changing that. He's not proposing it over land that doesn't
Well,
exist.
the subdivision,
He's just
however,
showing you.
at 47 years of age, doesn't exist any longer. It's the dedication that's left. The dedication of the road is
This is
left.
still of record.
It's of record.
It's of record. This will continue to exist in perpetuity until it's amended or abandoned. This, once you file a subdivision map, it's there forever. So I would
The issue is, could he
disagree.
walk in and get a building permit on it?
On this, if he owned that and he wanted to put a house on that, sure he could. Based upon this subdivision,
Yeah, but
that's a
we're-
lot that was approved back in 1961. You could build a house today on that lot, it's an approved lot. Even if this lot today doesn't meet your subdivision regulations on lot size. Because this was approved back in 1961, assume it sat unimproved for 60 years or 100 years, I'd be able to put a house on that today. So yes, this continues to exist in perpetuity until it's been amended or abandoned by the town, or by a subsequent applicant. The question is, can he build to the north? You've heard my opinion, I think we've all expressed our
Vinnie,
opinion.
I would like Vinnie to answer this. It sounds like that anyone else could build there except Denny because of the
No,
lawsuit.
it sounds like the only person
He
that
has
can
no
go forward
right.
and build for it right now is the town.
If they choose to take the step of acceptance,
Is the only person that right now has the right to
And they
Accept
haven't
that and build
evidenced any intent to do
Yeah, but
that.
if someone else owns it,
of someone else.
there's no legal,
The issue is, to the extent, I think getting to your question is, this property up here, this property owner here,
Right.
to the extent that there's been a judicial determination that this property owner has no legal interest in this parcel.
right.
That would, something in my opinion, that would bind any successors and heirs of this property owner. So if Mr. Denny sold it to Blackacre, that judicial finding would
Still carry over?
carry over, in my opinion.
But now, of course, Mr. Denny is also the only person in the town of Orange who is precluded from challenging an abandonment of the property, of the road, because of his agreement with the town. He's in a.
True, but he
he's in a
also
bit of a
could,
pickle.
he could sell that, for instance, to his wife, and then she'd signed off on no such agreement. I don't think it was
Possibly,
just- I
whether
think- I think it was
it
just
runs with the
as
land
well.
or not may be a
Yeah.
legal issue,
Yeah.
but, you know, ultimately, we aren't at that point right
Right.
now. So, Mr. Denny, as the record stands at this moment, cannot construct the road on the proposal, cannot access his property, and cannot access the proposed subdivision. He can't on the record that he has before you.
Can I respond to that?
Sure.
He said it 4 times.
Then it must be right.
The only thing that small piece of that case said was that under the statute, he didn't have standing to argue that he had,
Under 13A 55,
that he...
because it wasn't abandoned, so
that he
therefore that
didn't have
argument didn't.
standing to argue that he had some title interest to that strip of land by virtue of an abandonment, which they found had not existed. That's all that small piece of the case said. And, in my opinion, an irrelevant part of the determination, because Part 2 said it was dedicated and it continues to exist as a public, dedicated land for public use for a roadway. So, that Part A of that case does not mean that he has no right to build that.
To put that in layman's terms, that decision, the judge said, you're claiming you can't go on there because you have a right to go on it because it's abandoned, and the judge looked at it, or in this case it was a trial referee, I believe, looked at it and said, it's not even abandoned, you're making the wrong claim here, so we're not even going to do
No,
that.
that's not correct.
Okay.
What they said is, it's not abandoned, and therefore you have no right-of-way, and it's not about title, you have
No,
no
no,
right-of-way.
but he argued under 1355 that he should have right-of-way because the road was abandoned.
He made no other arguments of right-of-way.
But the trial referee said,
You don't have a
no,
right-of-way.
that's not true because it's not abandoned.
However, if he had a right-of-way under any other claim, I would assume he would have claimed it, because he was
Well.
claiming, I want to participate in
Or,
this decision.
he's a victim of,
So he was wrong in his determination that he had a right-of-way. It doesn't matter.
He
It's
doesn't have a
dedicated for
right-of-way.
public use. The public has the use. He is a member of the public. Essentially, what he would be doing in building the road is improving the dedicated parcel of land for public use at his expense to access his property to the rear for the subdivision.
I guess my question for
By
Mr.
bonding it-
Botry is, and please stay here, is the judge ruled on his claim under 13A 55.
Yes.
And the judge ruled that he had no standing under 13A 55.
It's out of the case completely. I
Because,
don't know whether his lawyer had another argument that he didn't raise.
right,
I
but
wasn't
that only dealt with that specific issue, correct? It didn't throw everything out of it. It just said, it just said,
It threw him out of the case.
well, it threw him out of that case because he came with the argument under 13A 55. So
I
therefore,
understand the position you're taking.
I'm just making sure I understand
But
it.
the problem is, I'm sorry, I got to get in front of I'm sorry, I'd like to be on TV. The problem is he hasn't demonstrated here.
Understood.
Any other right to access to the property. So had he had another right of way, he could have raised the issue, tried to get a court to determine it, come in here and said, I've got a right of way because the only argument he's raised is that this is a dedicated road. And I've seen nothing before you that suggests the dedication of a road without acceptance creates any right-of-way, including to the public. There is not a public right-of-way here. There is a public right to the town if the town chooses to do something with it, and that right will be determined at that time. But the reality is that there is nothing in the record that Mr. Denny has put before you that says he could build that road or even cross that land to enter his own property. plus he'd be walking through people's lawns, they might notice him. But at the end of the day, he has not done that. And so you'd be approving a subdivision with no record of access to the property. And I do know that if presented with an entirely landlocked piece of property, you would not approve a subdivision on a landlocked piece of property unless the owner provided some right of access, by right of way or something, unless they're going to visit their homes by helicopter, and I don't think our regulations have established that yet. That's the defect here. Besides the defect that the way to accomplish that would be to have these owners sign off on the application. Okay, we agree with the application, we know you're going to put a road over our property, we're okay with it. They haven't done that. So you're...
In terms of our decision, though.
Yeah.
Is this where we started?
We start right back to the owner. I've been good at doing that.
You've put into the record your evidence to the effect that there is no access to this property. The applicant has put in evidence contrary to that. Would you agree with that?
I don't believe so. And the reason is that the only thing he's established is that there's a dedication. He hasn't made any argument that suggests there's a legal right to cross that property.
Well, what he's saying is it's a right that exists in favor. It hasn't been improved. I mean, there are rights that exist now, and I think you conceded that. Whether it's
some right to the town,
right?
Yeah, but not to Harlan Denny.
Well,
I mean,
but he argues though that it's a right in favor of the public, of which Harlan Denny is.
Well, but the problem is it's an inchoate right. There has to be another step. And as you pointed out right at the beginning, I think that this issue of dedication and acceptance, the appellate court decision seemed to suggest that within acceptance itself, there was a need for the town to have some sort of acceptance also. We don't have acceptance. So
nobody's arguing that, because the town is not going to accept it until it's built in conformity with the regulations.
Mr. Denny can't build the road in conformity with the regulations unless the town accepts it. So the question is
But didn't the town accept the subdivision in 61?
They
whatever year that was?
They accepted they didn't accept the subdivision. There was a Planning and Zoning Commission decision to approve a subdivision. There was no subsequent acceptance of any, there was no acceptance of the roadway, and your approval doesn't create or constitute an acceptance by the town of a roadway.
Can I just answer for the record the question that he answered for me? That said, I didn't give you any evidence. The answer is, this map is evidence, and the court decision is evidence that is sufficient for you to approve this subdivision to the north of a parcel that has been dedicated, which will then be improved as a condition of your subdivision approval. We shall improve upon the land that you have the right to order as a condition of the approval that the subdivision, that the road be built in conformity with the town standards, at which point the town then would accept the road, just like they do in every other circumstance. There's already been dedication. The approval, which I think you're well within your means on this issue to give, would then lead ultimately to the construction and acceptance. And so this map and the court decision is the evidence that I think is the only evidence that we need to show you under these circumstances.
Just for the record, that map, which I think was part of my notes, I don't think has ever technically been added to the record. So just so the applicant is aware, before any public hearing is closed, to the extent that you're referring to it.
Can we mark it and offer it?
It's up to the chair. I just didn't want you to be believing to think that was something that was submitted by your clients before you got here.
In light of
I think it should be submitted for the record.
references to
Yes.
the map, it should be.
Yeah,
if
it
it
should be.
hasn't been.
Yeah, it should be
made part
submitted
of
for the record. I have two questions that has to do with the plan itself. One question was, do we have the proof of notification to the adjoiners? I saw there was a
Yes, we
list,
do.
but we do have all the proofs back. And the second part of the plan, I know was addressed the first night of the subdivision. The plan that's before us still has a notation that these lots will be serviced by wells. I know that the developer stated that no, that is not the case, it will be serviced by public water.
Yes.
But we would, if we ever get that far, we need to get the plan altered so that it does not
Actually,
affect-
we get a written letter from the water company.
Okay. And do we have a letter from the water company, because we're supposed to have that prior?
No.
Okay, so we need to, so in order to close,
Or we can make it conditional. You know, we did that the last subdivision, we did that.
did we make it conditional? No, I thought we
Farm River
insisted that
Estates,
they,
Farm River Estates, we made it conditional.
How about water pressure? Then we have or that won't matter for here.
The fire marshal signed off on that.
Signed off
farm
on it?
marshal has to deal with that. But I thought with the Farm River Estates he provided us, we made it conditional on that letter?
Yes.
Okay. Part of our subdivision regulations, we require a letter from the water company stating that it is feasible to bring city water in, or public water in. Okay. Is there any other evidence or testimony that anybody from the public would like to put forward at this time, before we close the public hearing? Does the commission require any further information that we feel is necessary in order for us to move to the next phase of this, which would be to close the public hearing and deliberate? Do we have a motion to close the public hearing?
I move to close the public hearing.
We have a motion?
Second.
Any further discussion? There being none, the public hearing is closed on this matter at 9:51. Do we want to deliberate this evening, or do we want to move on with the rest of our agenda?
How much more of the agenda do we have here?
We've got a few things that should go fairly quickly. We've got, why don't we move on with the rest of the agenda, and if we are so inclined, we'll go on with our deliberations afterwards. Next item on the agenda is a review of the minutes from the May 20th, 2008 meeting. I have reviewed the minutes and found no issues.
I don't have anything either.
I don't know, I won't second.
Okay, I'll move that we accept the minutes for the May 20th, 2008 meeting.
We have a motion? Second. Any further discussion? There being none, all those in favor of approval?
Aye.
Aye. Unanimous. The next item on our agenda is a discussion relative to requiring department head signatures for site plan applications, architectural standards, supplements, rather. This, we brought up at our last meeting. This is an email that I got from the fire marshal requesting that he have a sign-off when we review architectural standards, the supplements. I thought it should be brought up. I think it's a good idea, but I thought we should have it as an agenda item and not add it to an agenda because it is somewhat significant.
We have all the department heads now except for the fire marshal?
No, we don't, on our architectural supplement application, we don't require any signatures.
I think it'd be a good idea to have all
Yeah,
department
in
heads sign
discussing it
off.
with Walter, sometimes there's some outstanding issues with regard to some other items. So, as a matter of fact, when we started discussing Tim's signature, I said, why don't we just, include all the department head signatures? Because sometimes there's outstanding issues, say, with the sewer connection or whatever, that, to tell you the truth, I didn't contemplate, when the application form was developed.
And I think it doesn't hurt to be redundant, even though these departments usually review these things down the road anyway, but it certainly doesn't hurt to get their input at an earlier stage.
I mean, it wouldn't include DOT and stuff like that. We're mostly talking building department
Yeah.
personnel, the fire marshal, the building inspector, maybe the health sanitarian.
I think it should be a rubber stamp, starting with the wetlands. After it's approved, Scott signs it.
Yeah, it would include wetlands.
Right.
And again, Scott is on the signature line of all the other
Then
applications.
when it comes to zoning, because this happened already, if the plan is changed because zoning requested something, that gets thrown away. Paul signs it, and it goes back to wetlands. And starts all over again.
If the plan has changed.
If they change, because that's what happened a couple meetings
Right,
ago.
but those get done, a lot of times they can get, if they're minor, they can get done with the review, and if the department head chooses not to sign off on it, then it's
I
fine.
think we're also talking two different, we're talking, that's with regard to the site plan signatures.
Right.
Yeah.
But we're talking
The
about the
architectural
architectural
supplements.
supplements, which really doesn't affect
Right.
many site conditions.
Unless it was a
But there's the
significant
thought
change
to-
to a roof line or
But
something of that
there's the
nature.
thought to put the signature lines on there because maybe there was a previously approved site plan, maybe some of the wetlands work didn't get done properly, maybe some of the S&E controls didn't get removed.
Or maybe a
So
certain
I think
roof
what it
line
is
might
it's
change
going to be an
and so on.
opportunity for us to take a close look at the site and say to the applicant, listen, if you haven't conformed, or if you haven't taken care of these fire code issues,
Right.
or if you haven't taken care of these exterior stairwell issues
Yeah,
on the
then you
building
won't get
code,
a permit.
then you're not going to get the permit
Right.
for the architect.
But I'm talking in general, there should be a stamp because of,
We do have a stamp that we developed, and we kind of
Okay.
tightened it up lately, Rick, by the way,
Okay.
so.
Listen, I'll move that we approve the requirement for all department heads' signatures for the site plan application for architectural supplement.
We have a motion.
second.
It's been seconded. Any further discussion? There being none, all those in favor signify by saying aye. Aye. Motion passes unanimously. Next item on tonight's agenda is old business. Does anybody have anything they wish to bring up under old business? Next item is new business. Being nothing under that, we'll move on to the report of the zoning enforcement officer.
I was on vacation quite a bit. I know I wasn't at the last meeting, and I also took my first full week off, I don't know, in 10 or 12 years. I've never been out a full week, so probably the biggest thing that happened was that the signs kind of went crazy on the Boston Post Road. I policed them over the past few days, and we've pretty much gotten virtually every sign out there that I've been able to see, with the exception of the new diner. I gave them some additional time to get the banners down because they needed a cherry picker to take the flags down at the new diner. Apart from that, there's a couple issues that came up with Lowe's and Home Depot. I fined Home Depot $300 for continuing to be in the fire lane. I talked to the manager on Friday. They're going to get another $150 fine tomorrow. I just had a resident come in with an accident report. There were more items out in the fire lane, and his vehicle hit those, and also stopped down there today, and that's still not get resolved, so they're going to get fined another $150.
This is at Home Depot?
At Home Depot.
Has Lowe's complied with our requests?
I talked and met with the assistant manager. I have an appointment at 10 tomorrow with Mr. Wright, is it, Tim? He's the full manager, and they've been cooperative, and he said he would do whatever he had to do. So formal order will be going out to Lowe's as well.
This came about, I had spoken to Paul about because Lowe's and both Lowe's and Home Depot had really moved, their outdoor displays were out into the parking lot to the point that it was, first of all, it's not allowed, period. But I mean, they got to the point where it was a clear safety hazard as well, and we felt that we had to move forward aggressively on that, and Paul has done so. You also had another issue that was brought to your attention?
Yeah, there's, and it may have been a resident in the audience tonight, Cricket Lane, there's a house in foreclosure, which I had cited for either under the anti-blight or for debris. It's in foreclosure. I had talked to an attorney about 6 or 7 weeks ago, or rather a realtor, and supposedly it was sold, but it appears that has not happened to date, so we'll take further action on that.
What action can we take on that? Can we force the bank to clear it up, or do we clean it up and bill the bank?
Well, the last 2 times I dealt with a foreclosure, it was an impossible situation. And I think Vin's somewhat aware of this.
Yep.
There was a holding company, a bank out in California, that had a subsidiary that was in Pennsylvania, that had a management company that was in Connecticut, and quite frankly, nobody cared. And you want to fine us, and I put something on the land records, and that was a house off of Penrose Circle over here. So it's a difficult situation. I'll probably look to Vinnie the best way to address it.
What I'll suggest, and today is Tuesday, I will be back in Town Hall on Thursday. I will check the land records to verify whether or not there's been any transfer subsequent to a list pendants being filed. What I would suggest is, to the extent that there's still a pending foreclosure action, that we address the attorney representing the bank at that point, get information. To the extent that we cannot get the leave that we want, there are 2 approaches that we could take. We could bring an injunction proceeding to really push the issue, or alternatively, we can do the work ourselves, send Public Works out there to clean it up so that we get the immediate relief that really the neighbors are complaining about that have not been addressed, and then take that expense and put it as a lien on the property.
I opt for door number 2.
Yeah, it's the less expensive alternative.
So that is to have the town go out, clean it up, and put a lien on the property.
Addresses the problem, still puts the burden on the homeowner, whoever it's going to be, or, whoever controls the property.
Do you want to see these pictures?
And we-
I'll look at them.
We're looking at them.
It's really egregious.
I'm not sure, but on foreclosure, what happens to the liens? Do they get wiped out?
Well, it's-
No, when the property gets sold, somebody,
They have to
when they
pay- they have
close,
to
they gotta
pay.
take
They
care
gotta
of
pay
that.
this
Yeah.
much money.
I just
Yeah.
Well,
was wondering.
it's postless pendants. So what we would then do is, as a postless pendants lien, I would seek to be made an intervening party in the foreclosure. The effect here is not so much the town getting its $300 to $500.
Right.
It's the effect of getting the property cleaned up and having it maintained in that order. I mean, there appear to be abandoned cars, whether or not those are registered cars or unregistered cars. So really, the point here is not so much of recouping the few $100s that we may expend in cleaning it up, but to send the message that we're taking this seriously.
Okay.
We're not going to allow a blight like this around the town.
I would agree with Paul. Let's move forward with option number 2 and just take more aggressive action on it. Is the board in agreement with that?
Yes.
Do we need a vote for that? Somebody care to make a motion?
Okay, I'll move that we, what are we doing? Go ahead, on Cricket Lane? I don't even know what the address.
Since we're getting the Public Works Department, what we should do is, instead of, we should probably make
A recommendation to
a
the Board of
recommendation to the Board of Selectmen that the Board of Selectmen authorize the use of Public Works to clean it up, because ultimately it's the Board of Selectmen that has the authority to engage in this type of thing. The actual address, is it 118 or 111?
111.
It's 111 Cricket Lane. So the motion would be to make a recommendation to the Board of Selectmen.
I move that this board recommends to the Board of Selectmen, that they send the Public Works out for 111 Cricket Lane to enforce it under the anti-blight statute.
Correct.
We have a motion.
I'll second it.
Any further discussion? There being none, all those in favor signify by saying aye. Aye. Okay. Okay, now it's 10 o'clock. Do we want to entertain the other issue?
Maybe start talking about it.
Yeah.
And
Well, the first issue is the length of the cul-de-sac. Before we go anywhere, that has to be decided. I think this commission has a pretty significant history of allowing these cul-de-sac extensions. As I noted before, there were 2 close to this length or around the same length that were approved the night of that this was originally brought before us. And we've had a couple others in the past. So we do have the letter from the fire department, we do have the letter from the police department stating that no concerns. We also have the letter from the Conservation Commission saying that they don't have any comments on this subdivision. So I don't have any objection to the cul-de-sac issue here. And again, this is completely separate from the subdivision application.
I was persuaded when we heard testimony from, boy, I have a mental block on his
Jeff
name,
Gordon.
Jeff Gordon, about the history of the cul-de-sac and the impact of it in Orange, and in this particular case, I have no problem with the length of it either.
Yeah, and even if you look at it, the length of the cul-de-sac is not going to be much more than the existing Cricket Lane, which is already in excess of what is allowed now. But apparently that regulation wasn't enforced at that time, or they received a waiver. But I have no trouble with the cul-de-sac length issue. So do we have a motion, or is anybody prepared to make a motion on that? And that regulation is 382-23G4.
Do we need to approve that? I mean, should we just have a discussion about that and then a discussion about the,
Collection was with two separate,
They're 2 separate issues.
because they're 2 separate standards to us. One is a supermajority and one is a regular majority.
Right.
yeah, but all I'm getting at is if you're not prepared to approve of both, the waiver.
It's a good way to get rid of the application right now.
So I mean.
I don't think that we should use this as a tool to get rid of the application, though, because
No.
we should deal with the issue of the cul-de-sac extension as a completely separate issue, not as a means of not going on further and doing our due diligence and debating the other issue. We have, as I said, even that night that this application was brought before us, I was absent that night, but the commission approved 2 cul-de-sacs over 1,900 feet. I believe one was 1920, one was 1955, if I'm not mistaken. And we've done similar cul-de-sac extensions in the past year, several times.
Yeah. And
Is this cul-de-sac that we're approving all the way up to the new Christmas tree, not the one he's going to build?
Yes.
Into the
Correct.
cul-de-sac?
Yes, that would be the, that, and what we're doing here is merely recognizing that we accept that there would be no issue if the cul-de-sac ever gets built to that length, which comes to the next step.
But the only issue I would have is, I just don't think he has the right to build a cul-de-sac. I think anyone else has the
But
right.
I think that's the argument for the next phase.
No, to build a cul-de-sac? To build
Well-
a cul-de-sac?
No.
You're
I mean, that's
just saying the length,
the length.
not to build.
Not to build. This has
Okay.
nothing to do with his ability to build it or his right to build it. This is
Okay.
just saying that if we go forward with the next half,
Okay.
that this portion of it, either we approve of that part of it or not. But we have to clear this one before we even consider the next one.
And, Mr. Chairman, I just want to point out, to the extent that you're going to deny the extension, under your regulations, you have to articulate the reasons
The
for the
reasons,
denial.
right.
So to the extent that it doesn't pass, you have to make sure that those reasons are articulated.
Right.
Okay.
Yeah, that's what I stated before, even before we got into this. So, do we have a motion on the issue of the cul-de-sac extension, or the waiver of 382-23G4?
Yeah, I'm going to move that we approve the waiver of Section 382-23G4, the maximum length of the cul-de-sacs and streets.
We have a motion. Does anybody care to second it?
I'll second it.
Is there any further discussion? There being none, all those in favor of the motion signify by saying aye. Aye. Motion passes unanimously.
Just a point of interest, since we've made that change, virtually every subdivision application that came in before the commission required and requested that waiver.
Yeah, we've,
Yeah, I
We've had
think
6 or
it's-
7 applications since that change.
We should probably revisit that
And
issue.
every single one of them has required and requested that waiver.
I think we should, as Paul suggested, revisit that as well. Now, we move on to the next issue. And I think my question is, to the commission is, I tend to look at it from the point that Ozzy had originally. I'm not so sure if he's certain of his original position. But as I said at the beginning, in looking over 8.2 and 8.3, which are the two general statutes that give planning and zoning commissions their authority and what authority we have, and in looking through what's legally required, and also our own subdivision regulations, and Mr. Pellegrino's point that this subdivision shows that road, so we are not dealing with anything to do with that cul-de-sac on that property, that we're dealing with just Mr. Denny's subdivision application. And in doing so, I think that his subdivision application meets all our regulations. I know darn well that Mr. Votri is going to take legal action to stop this, and I think that's where it's going to end up in court. At the very least, it's going to end up with the Board of Selectmen, but I think eventually it's going to end up in court anyway. But I do agree that he has shown us his plans to access this and how he plans to access it. That, again, I don't believe would give him, based on just our authority, the ultimate right to go onto this property. But he's showing us how he proposes to do it. And that, I think, is the issue that's before this commission. Thoughts?
Well, I just didn't think, I'm not sure, but I thought he had a certain time frame to build this road back when he was approved, no?
Well, that was a separate issue, though.
That was a
because
separate
that was
issue,
because-
which he failed to do.
But that was a separate private agreement that he wasn't given a time limit to build the road. He was, if I recall from the without looking at the agreement, if he got approval from the Plan and Zoning Commission,
Right.
he could move forward. And I think there was a 2-year time limit, perhaps.
That he expired.
But that was only an agreement too. That at that time, that the agreement with the agreement was with the acceptance with the Board of Selectmen, that he had to do this within a certain amount of time. Otherwise, their acceptance expired.
Right.
So, again, he's put back in the same place as far as I'm concerned. Just because if this commission agrees and goes forward with the subdivision approval, in my opinion, he still has to seek other approval.
I know.
He still has to go to Board of Selectmen. Mr. Marino has expressed that he would not advise that the Board of Selectmen take that same approach that they did before, and I think that's the right decision. I think that in doing so, the way that the former town attorney had done it left the town open to quite a bit of exposure.
Well,
But again, I don't think that's our decision.
Right. I just don't think he has rights over it.
Yeah, my point is, I don't think that it's up to us to decide if he has the
Well,
rights
anyway,
over it
but
or
that's
not.
going to be my reasoning
Yeah.
for that. It's just because I don't think he has rights
You don't think it's been demonstrated?
for him.
that-
Anyone else, I think, has rights that bought the property. I don't-
If people bought the property,
I don't
oh, you
think-
mean if somebody else bought his
If
property?
someone else bought his property, I don't think they will have an issue like he does. That's my opinion.
I wouldn't agree with that, because
No.
I think that, because I
I
think you're
don't
basing it
believe-
on the previous agreement that expired.
Why would they have the right to go on the
Yeah.
property?
Because
if he
according to
does?
what they said, that Harlan Denny did not have rights after this court case was done. That's
No.
what he stated.
He didn't have the rights under, the judge ruled that when he brought this argument,
That he can't argue against.
he argued that under Connecticut General Statute 13A55, that because this road was abandoned, then he had no longer had access, so therefore he had a right to go over this abandoned road. And the trial referee said, it's not even abandoned, it's a crazy argument, forget about it, you're out of here. And he didn't put forward any other arguments. Now, I would say that's, poor legal advice, but that doesn't say that he can't come forward with another argument another time. He never has.
Right.
But that's something he's going to have to come forward with, my guess is in the very near future. But I don't think that when you get shot down from one argument, that says that you can't come back with another argument.
I also think the Board of Selectmen should accept the subdivision, or, I know they won't accept the road until it's built, but
Well, they did last time,
I know,
but
that's what I'm saying.
Mr. Marino advises against
Right,
it.
so I think they should accept it, and then there won't be any issues. There won't even be legal issues.
Well, I think
A little
Mr.
bit.
Butcher said that there might be legal
Yeah,
issues.
there'll be
even if
legal
they-
issues, but I still think the town should accept it. I think the town should accept the road.
Well, again, that's,
Huh? The
Just-
the
just
town
a-
has to accept the concept or accept that
kind
subdivision.
of a layman's capacity, and you're kind of being asked to deliberate kind of legal concepts. There is an argument to follow Rick's line of reasoning, is that there's a doctrine of collateral, of estoppel, res judicata, where a party was part of a lawsuit. Just as you play into your deliberations, although some of you are lawyers, you're sitting here and from raising it in a subsequent lawsuit. So it is possible, okay, as a matter of law, as a legal doctrine, that, before the table. I think it goes back to where Ozzie brought us the conclusion of our last meeting. And so as you go through your deliberation, it's somewhat difficult, and you may not want to rush, and you have time, although if you feel you can move the question, then move the question. But if you may want to digest the issue a bit, because you are dealing with, you're raising questions that then raise legal issues, legal doctrines that you're not familiar with. And of course, if you go one way or the other without asking the questions of where does this, what would, if we went down this path, what would be the outcome, in my opinion, you may come to a decision that ultimately may not withstand scrutiny. So my thought is, you've gone through your first part of it. If you want to sit around for another few minutes to see whether or not you can get to the end of it, but you may want to digest, there was a pretty substantial legal record of decisions and whatnot, and digest that a little bit more, so that when you set forth your reasoning for approval or denial, you're setting it forth, and you're not doing it, with the eye of, let me get home at 10:30 at night.
well, I think at this point, the idea of going home really has passed us.
Let me just chime in here a little bit. I think actually, Vin, you and Ozzie were very persuasive, at least to me. And I've gone back and forth. Mr. Votri and Joe Porto had me going like a ping pong ball, I felt, at various times over the last couple of weeks. But where I'm at is that I think Ozzie really hit home with the fact that what's before us and what our charge is for me focused in on what is the subdivision application. And here, the subdivision application, if I understand what Vin said, and I think it makes sense to me, is without regard to the access. In other words, the question of access is separate. to me, the subdivision application meets the requirements. See how we now claim that there is no dedication or various rights to the town. Now, I firmly believe that, they're going to have tremendous problems in building. The issue of the access is, I think, answered by Bernie Pellegrino's comment with regard to the Grillo subdivision, which has been approved by this board before. I don't think, but that's for a different forum. And I think if this came before us, we would not be asking about title. We wouldn't be asking about other issues with regard to who owned what. We would look at it and say, does this comply with zoning? I think it does. So I don't know how we get around from our charge for doing that. That presupposes that you go with the idea that the road is not part of the actual subdivision in front of us. Because if it is, I don't think there's been a showing that the owner of that has signed off.
I would agree with you completely.
Well, that's why I think the town or the Board of Selectmen should say, to give the sign off or the blessing that a road could be built there. That's all. Once they say, yes, you could build a road there, there's no issues.
Let me ask you a question. In any other application, would we require that?
If this never came up, if another application came up, I would think the town has to approve it.
I think what Paul is asking is, just for argument's sake, if the owners of the property, the Brennans and the Tomays, didn't contest this, if they just, looked at their map and said, okay, we knew this when we bought the property, this was going to happen, and they didn't have any objections to it, this would not be an issue before us.
That's right, but because they say they own the property, the town should clarify it.
Well, that's what
It's very simple.
I think what Paul's saying is, though, and I agree with him, is that, yes, you're right, but that's not for us to decide. What we have to look at is say, as they pointed out, we have a subdivision that shows this road. Mr. Denny is saying this is how he's going to access his road through this right-of-way. If he ultimately does not get approval to access that road, that's his problem.
Well, the thing I don't like about this is because it's not going to the selectmen after we vote.
It's going directly to
It's going to court. I would think it's just, if they could just ask, we could just vote and say this.
Well, there's another thing here too, though, is we just closed the public hearing, so that we could not bring in a decision by the Board of Selectmen, is my understanding, at this point, because it's evidence that we would be entered into after the close of the public hearing. Is that correct, Ben?
Answer that question.
Your public hearing is closed.
Correct. Yeah, I know that.
Right.
Even now, I'm sure of that. My point is,
Judy just texted me and she said the public hearing is closed. She said, please vote.
my point is that even if the Board of Selectmen, if this were to come before the Board of Selectmen,
Just for the sake,
and they
This-
accepted it,
this will be
we
on the
could take that
agenda.
into our,
This will be on the agenda at the next Board of Selectmen's meeting on the 18th. It is going to be my position with the board, as I stated today, that they should not accept that road. If they do anything, they should express their intention. Their intention is going to be to accept the road. If their intention is not to accept the road, then there should be a motion to abandon the road, and then that would have to be referred to a town meeting, which would occur next May.
and I think in addition to that, though, no matter what action the Board of Selectmen took, because we've closed the public hearing, we cannot take that evidence into our consideration at this point. So,
Let me, as a matter of course, though, if we approve a subdivision, not this, any subdivision, and the road, the subdivision roadways get built according to plan, is there any reason why the Board of Selectmen, are they compelled to accept it?
No. But again, what you have is a subdivision map of record that shows the right-of-way. If the Board of Selectmen, if you approve this subdivision, and the Board of Selectmen ultimately determine to abandon the road, then Mr. Applicant will not have a way of accessing his property, and your approved subdivision will fail, basically over the course of time.
or if the court decides that there's no right there.
If this was approved tonight, they can't abandon the road then. Why would they go the other way around?
Why? Because the suggestion would be that as it was a referral from this board, a municipal improvement in 824, that there would be the recommendation that they should. That's not binding on them, but what you do here is not binding on them there.
No.
It's a recommendation. So ultimately, arguably, any subdivision that you approve, the Board of Selectmen could say, we're not accepting this as a public, make it a private road. We don't want to raise
don't wanna plow
taxes
it, we don't wanna-
to plow it and to maintain it. Let it be a private, you know what? If this were the Cricket Lane subdivision and the town said, we have enough roads, we don't want any more, Cricket Lane can be a private lane, that those owners there could maintain that road, we don't want it anymore. The Board of Selectmen doesn't have to accept. It then becomes a private lane. So then ultimately, though, if you have an abandonment by the town or a failure to accept, it would make the property owner's argument more persuasive to a judge. If you have
They would seal it.
right? If it has an intent, if you have an intention by the board to accept it upon completion, I think it would go in the other direction. But keep in mind, what you do here is essentially a recommendation to the Board of Selectmen, not binding on them.
And my thoughts were also predicated in no small part on the fact that our predecessors approved that subdivision in 1961. And as Bo indicated, I think Vinnie did too, that people had notice of that. And that is, certainly weighing upon me when I was thinking about this.
Yeah. And as I said, it was a thought that I couldn't get out of my mind, is that not only did the property owners of the right-of-way know this, but Mr. Denny also, I would assume, when he purchased that property, took that into consideration, that he could access it in that fashion through that right-of-way. The subdivision that's before us, I accept Mr. Pellegrino's argument that the fact that this roadway is shown on the previously accepted subdivision points out to the fact that it is completely separate from the application that's before us. He's just continuing on showing you a previous subdivision, Mr. Denny is, where it applies to his subdivision application. So I do think that the two issues are separate. And, I have no doubt that a judge is going to make that decision one way or the other, but I think that this board, and again, I don't think that we have the authority, even if we wanted to make that decision. So not only do I just don't feel that we should proceed down that avenue to say that he has the right to go down that road. We're just agreeing that we are just, whether that was the correct assumption or not, I guess we'll find out in the somewhat near future. But again, I think that Ozzy's point that what we have to consider, if we agree with this, we are just agreeing that the application shows his intent to access it. If he can access it the way he's providing he's demonstrating to us how he wants to, then it meets our requirements. If he can't, then he's back to square one.
Sue Leonard's was a nice example, although it's been a number of, I'm sure, other examples of the roads that were not owned by the applicant. They may have not been built, they may be built, that's not before us. What's before?
The argument, one of the arguments I took was that they can't use that for their traffic plan because the road didn't exist, but different point.
That was even a more extreme example because it wasn't even a right-of-way.
There's
The
nothing.
town had not condemned that that was private property that they were showing their road over. It was an anticipated future eminent domain, but it wasn't even an approved subdivision.
Yeah, it
So
was-
that's an even more extreme example.
Is anybody prepared to make a motion?
I'm certainly prepared to make a motion. Do we want to wait for Judy, or is that something that board is something that we want to do?
She didn't express a desire for us to wait. I think she would have if she, was concerned about it. So you can go forward.
Then I'm going to move that we approve the re-subdivision application of Annie Acres submitted by Harlan Denny for property located at Cricket Lane, Dogwood Road, also known as Assessors Map 65, Block 1, Parcel 1. The proposal is to subdivide 9.09 acres of RES residential zone land to create two lots. The also proposed is the construction of Christmas Tree Lane to service the lots. I would say that, I'm sure I have to make this as a condition, that Christmas Tree Lane be constructed in order for the subdivision to ever be built. Yeah, it's on the map.
You don't have to.
We do have to.
But what you might want to include, Paul, is all our standard conditions, which includes a pre-construction meeting, bonding, Also the submission of a variety of maps to municipal departments,
I'll so amend my motion.
and verification from the water company for the extension of the water line.
Yeah, and the amendment to the application where it has that the lots will be served by wells.
Yeah. Actually, there is a note on there that they're going to be served by public
Okay.
water in another location, but we'll amend the maps.
We'll amend the map, so.
I'll amend the application. I mean, the motion.
We have a motion. Anybody care to second it?
Second.
Any further discussion?
I just make one comment. I think on that question regarding 382-13 that we raised, I'm in agreement with Attorney Pellegrino's position on that, everybody who needs to sign the application has signed the application. That specifically that the property to be subdivided is property that, I haven't heard any evidence to the contrary, that it is property owned by Harlan Dent,
Mr. Dent,
by the
yes,
applicant. So I would just add that as one of our findings.
Okay. And you seconded the motion, correct? No, Rick did.
Rick
Okay.
seconded.
We have a motion, it's been seconded. Is there any further discussion? There being none, all those in favor of the motion signify by saying aye.
Aye.
Motion passes unanimously. Now, Paul,
I move to adjourn.
we have a motion to adjourn. Second, all those in favor signify by saying aye. Meeting adjourned at 10:28.